Good morning, everybody, and welcome to Mickaboo's virtual holiday party. The COVID-19 virus is still rather unpredictable, and these things, as those of us who plan holiday events know, you need to plan about a year ahead of time if you want to get a decent physical place. So given where the pandemic was earlier on, we said, we're going to play it safe for ourselves and our attendees and go virtual this year. It is entirely possible that we'll feel comfortable enough to do a in-person next year. But for this year, we've got several events planned for you, the first of which is the highly anticipated Estate Planning Essentials by Alyssa. Last year, Alyssa was here along with Ellen, another attorney who is an ardent Mickaboo supporter, and they talked about pet trust, which is a fascinating topic. And this year they are doing Alyssa, is doing a follow-up to go a little bit further into the topic. Before we pass away, we still have to do a few things to make sure that we're good and that our pets are good, particularly birds, because birds live a long time, as we all know. While the presentation is in progress, please put your questions into the Q&A. And I will call them out to Alyssa, because Alyssa is going to be very focused on her presentation, but let's make it interactive. Throw them into Q&A. I will throw them over to Alyssa. Alyssa also has a few questions that were sent to us via email yesterday. So she will be incorporating conversation about those questions while we go along. Right. So again, questions into Q&A. I will make sure Alyssa addresses them while we are in progress. The deck that you see and will see on screen will be available to us afterwards, as well as a recording of this session. So if you have friends and family who really wanted to be here but had other commitments, all good. We will be happy to share the content afterwards. But because you are here, you get the special privilege of being able to ask your questions right now. So without further ado, here's Alyssa.
Thank you, Pam, and thanks for everyone who's attending by Zoom this morning. So really, today I'll be going over some estate planning essentials. Last year I did, or Ellen and I really dug into pet trusts specifically, which typically occur, after you've passed away. And so we'll still be talking a little bit about pet trusts today, but I'll also be going over some of the really critical documents and instructions that you may want to consider putting into place during lifetime, because there's sort of a limbo period that you might experience during lifetime if it's a temporary or potentially temporary or permanent incapacity, I should say. And so we really want to make sure that you and your pets are protected and that it's really clear what should happen and what your agents or trustees or whoever it is who you leave in charge, that they know exactly what they're supposed to be doing. All right. And just a little bit about me. So I am an estate planning attorney in the Sacramento area. So my office is located in Sacramento, born and raised in Sacramento, but I do provide services for people all around Northern California. So I work a lot with people in the Bay Area. Thankfully now with Zoom and remote work, it's pretty easy to work remotely with folks. And so I work in mostly everywhere in Northern California, but a couple other types of law that I also do practice in the area of trust and estates. I also do conservatorship work, probate work, and general administration work when it comes to during lifetime or post-death. So when we're talking about estate planning, I've seen it on both ends where either there are proper documents in place or there aren't proper documents in place. And so a lot of my advice when it comes to the estate planning side is really geared towards minimizing any conflict or minimizing any ambiguity when it comes to your instructions. So grew up in Sacramento area. I went to UC San Diego for undergrad, and then came back to Sacramento for the McGeorge School of Law, which is a branch of University of the Pacific. Okay, so I always like to kind of start on a baseline, talking about what actually is estate planning. I think a lot of people don't realize that they're already doing some form of estate planning, even if they haven't met with an attorney yet, or they haven't done any formal documents yet. Some examples of post-death estate planning that people are probably already doing would be one, beneficiary designations. So if you consider certain accounts that you may have, like life insurance policies or retirement accounts, if you have a beneficiary designated for those types of assets, then that's a form of estate planning because you've already directed what should happen to those assets upon your passing. Now, normally, those are only going to be limited to individual people. So if your concern is taking care of your pets, there's really no way, at least currently, to do direct beneficiary designations through those types of assets to pets or for the benefit of pets. And so that's where the legal documents will really come into play as far as giving you the ability to control all of the parameters of how funds are used. Another method of estate planning that people are probably already engaging in as well would be taking title to property. Most often, this is going to come in the form of real estate. So if you purchase a home and you take title to that home, whether it's your name individually or with a spouse or a partner or just another third party, the way that you take title is going to determine what happens to either the entire property or just your interest in the property if you either become incapacitated or you pass away. And so we'll talk a little bit about what that looks like if you don't have any estate planning documents or any formal documents that dictate what should happen to any interest that you have in real estate, for example. And really a big focus of today is going to be on the legal documents that you may want to consider. The big one, I would say, is really going to be your revocable living trust, and we'll talk about what that is. We'll also talk a little bit about a last will and testament, but I'll also be explaining why that may not be the document that you'll want to be focusing on or the document that you're going to want to rely on for a number of reasons. And then we'll also talk about how a durable power of attorney for finances can be really, really helpful for you during your lifetime, and then advanced healthcare directive, at least on the medical side. All right. And so who really needs estate planning? A lot of people will ask me, do I need a trust? Do I need a will? What do I actually need? Right. And so at a minimum, anyone who's over the age of 18, so any adult, should at least consider having a durable power of attorney for finances and an advanced healthcare directive. Those documents are going to be critical for you just in case during lifetime you ever become incapacitated. Those documents really give you the opportunity to identify who can step in and assist you with anything financial or medical in nature during lifetime. And that's a really good opportunity on the financial power of attorney to be able to dictate how funds should be used, not just for you, but also for any pets that you may have. And then a living trust is typically going to be appropriate for kind of two categories or two considerations. One would be any beneficiary who really needs money to be managed on their behalf. Normally, that's going to mean if you have a minor beneficiary, so anyone who's under the age of 18, if you have any pets, because pets can't manage the money themselves, and then those with disabilities. So there's different types of trusts that we can also create when it comes to adults with developmental disabilities or anyone with disabilities, where you may want them to still be able to inherit, but not necessarily become disqualified for any public benefits that they may be on. That's a whole different topic, which is sort of in the realm of special needs or supplemental needs trust, but just something to consider if you're not quite sure and you're on the fence about whether a trust is appropriate for you. And then in California, a trust is generally also going to be appropriate for anyone who has an estate worth over $184,500 in value and or any real estate. Normally in California, if you've got a piece of real estate, the fair market value is probably going to be over that number. And so for the most part, anyone who owns a home, it's probably a good idea to consider doing a trust. I would recommend that you at least speak with an attorney though, because like we mentioned, or we discussed on the previous slide, the way that you take title can really depend on what happens to either your interest in a property or the entire property itself. And I also have a little asterisk down there that says that $184,500 value currently applies to any deaths that occur on or after April 1st, 2022. There's a slightly lower number for any deaths that occurred before April 1st, 2022. So again, if you're in either of those boats, just make sure that you consult with an attorney just to make sure that you're in the right area. So first, kind of what happens if you don't have any legal documents in place, meaning no power of attorney, no trust, no will, right? Any of those situations could potentially be an uphill battle, either in the courts or otherwise. For the most part in California, the default, if you don't have any estate planning documents, means that you're having to deal with the probate court. Now, the probate court, if you haven't dealt with it before, I'm in the court very frequently, and I can tell you that no matter what county you're in, anywhere in California, anytime you have to deal with the court system, it's generally a very lengthy process, quite an expensive process, and also a very public process. It's also very formulaic in the sense that the court has guidelines that they are going to assume that you would have wanted in lieu of you putting your own instructions in place. And so especially when it comes to pets, unfortunately, they sort of fall by the wayside if you ever are in a situation where you end up in probate court and then the court is kind of dictating how things should be managed or how your affairs should be handled. I've seen it many, many times where somebody has either passed away or become incapacitated and they have a pet in the home. And while there are ways that you can sort of jump right in for emergency requests with the court, it can be quite expensive to do that. And the court has a little bit, they have a heart to a certain degree. They understand that a life is at risk potentially if you do have a pet that needs care. But at the same time, their focus tends to be on you, the person. So when it comes to if you're living but become incapacitated, they're going to focus more on your well-being. They're not going to care so much about the well-being of your pet. And if you've passed away, same idea, they're going to care more about any of the intended beneficiaries or heirs of your estate rather than the pets themselves if you didn't. And again, this is all considering if you did not have any estate planning or legal documents in place. Just to really quickly give you an idea of what I mean by each of these different categories. When it comes to lengthy, the court's super, super busy. It means that it can take months to achieve a resolution in the probate court. So even though in some cases you can request an emergency order or for some form of emergency relief, it can take a very long time to achieve permanent resolution to any particular issue, whether it's during lifetime or after death. And so this kind of leaves you or your loved ones in a state of limbo while the court process is playing out. That's not always going to be the best, especially for our feathered or furry friends if, their whole life is disrupted as well for that type of process. And especially if you're family members or if you don't have family members who are able to step in, if, somebody else has to step in, it's kind of, again, they're not really focusing on your feathered and furry friends. They're focusing more on you in that situation. So again, lengthy kind of leaves them in a limbo state. It can also be incredibly expensive. So I kind of have it broken up into two categories here. If you ever become incapacitated, it can be very costly for your family or any other person involved to hire an attorney to have to assist with establishing what we call a conservatorship for you. And I don't know if anyone has heard that term conservatorship before, but if you know Britney Spears, that would be a good example of someone who comes to mind who, they're ended up in a conservatorship, and it's a very expensive process. I don't even want to know how much money went into her conservatorship, but anytime the conservatorship process has to be started, that really means that the court is overseeing pretty much every step of the way, whoever steps in to manage things for you if you become incapacitated and again you don't have any legal documents in place. So every time you have to go to court, there's a cost, right? And it's a pretty difficult process to navigate, and I've seen people do it without attorney assistance, but it is pretty difficult to do without representation. And then on the other hand, if you were to pass away, the probate court also does set attorney's fees and executor's fees based on the fair market value of your overall estate. I'm going to assume that a lot of people who are logged on here are probably in the Bay Area, which means that real estate is very, very high. Value of real estate is very, very high. So the courts will typically calculate, or I shouldn't say typically, they do calculate all of the attorney's fees and executor's fees based on the fair market value of your overall estate. They don't care if there's a lien on the property or a mortgage. They look at whatever the fair market value is. And so it can be very, very expensive. Just a really quick little breakdown of how the court calculates that. And if anyone's curious, it's Probate Code section 10810. They do it based on a sort of a graduated scale. So it's 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, 1% of the next 9 million, 0.5% of the next 15 million, and then a reasonable amount determined by the court for any assets or estates worth above 25 million. So you can imagine that even if there's one piece of real estate worth, $1 million, that's still a pretty significant amount of fees that are going to third parties when, you may want to, it's much simpler and easier and quicker to just do an estate plan now. So you hopefully don't have to worry about probate and all of its fees. And then finally, the probate court is incredibly public, meaning that most court records and certain types of court hearings are available to the public. This means your personal information, the personal information of any family members who are involved, all of that is subject to either purchase or viewing by members of the public. Nowadays, too, with COVID, a lot of hearings are held by Zoom. And so anybody can just pop into a hearing and see what's going on, or a lot of times hearings are also live streamed. And so if you want to keep things relatively private or out of the public eye, then doing some estate planning is probably going to be your best bet. Because if you don't do any estate planning, you're looking at a very public situation. One common misconception that I hear quite often is that if you have a will, that's really the only document that you need. And unfortunately, that's really not the case. So that magic number we talked about earlier, which is that $184,500 value, if your estate, meaning any assets that were left just in your name individually, that you didn't own jointly with someone else, that you didn't have a beneficiary for, or that you didn't have in a trust, if you're sort of in that category of assets and all you had was a will, then you actually are required to go through the probate court process in order for that will to be administered, because the probate court is the only entity with authority to oversee the administration of your estate at that point. And so for a lot of people, you do get some benefits if you decide to do just a will, but it's not really going to help you avoid the probate court in any particular way. You still get to control some parameters as far as who would be managing the estate and who ultimately would benefit from the estate, but you're still having to deal with the court and all of its oversight. And so really then the next question is, what's the big difference between a will and a trust? With a will, you're likely going to have to deal with the probate court process just based on the total value of assets and what types of assets you have. It's a very public forum and it's only effective upon your passing. And so, a big focus for this presentation is how do we protect you and your pets? Well, if all you have is a will, you may be able to sort of direct or dictate what happens to assets upon your passing, but that's not really going to help your pets at all during your lifetime if something happens to you and you can't take care of them. And it also potentially puts them in that limbo situation where, because it's such a lengthy process in dealing with the court, there may be sort of a lull period where there's nobody taking care of the pets while we wait for the court process to play out. So just something to consider as well. Now we're going to sort of dive more so into the trust and the types of documents that I think are really going to be helpful for you, and some considerations that estate planning attorneys, whether or not they do pet trusts or really know a lot about pet trusts, some things that you can always talk with attorneys about, and then they can structure your estate planning documents to help support you and your pets. The big benefit of a trust is that at a minimum, the whole goal of a trust is to avoid the probate court. So assuming that it's done correctly and that assets are actually properly what we call funded into the trust, then it should not require probate either if you become incapacitated during lifetime or after you've passed away. Another really good benefit of the trust is also that it's privately administered. A big question that I get from people is, okay, well, if I do a trust, where does this trust go? Who has it? Does the court have it? Do we record it somewhere? And the answer to all of that is no, it's your document. And so, you get to share it with whoever you want to, or if you don't want to share it with anyone, you don't have to. My only recommendation would be to let your successor know where you're keeping a copy of the document so they know where to find it. But ultimately, it's all privately administered. And so it's sort of a closed universe with as far as who will eventually get to see all of the terms that you put into this trust, and how it's administered will also be done privately. Now, a small caveat to that would be if people are fighting or if there's ever any drama that comes up with the documents, the court tends to be I don't necessarily want to call it the mediator, but some people will go to court to try to settle any issues related to trusts. But if you're working with an estate planning attorney and you're really advising them of all of the main goals that you have and any foreseeable contests or issues, then it's really, really critical, because then they can work with you to try to set things up to minimize any potential contests in the future.
Hey, Alyssa, we have a question. We
Sure.
referenced a estate value threshold earlier, and the question is, how often is that threshold raised?
Oh, well, it's interesting. So that the threshold's been raised a couple of times. I want to say maybe 2 years ago. So for a very long time, the threshold was $150,000. That slightly got bumped up to $162,500. And then just last year, they bumped it up to earlier this year, they bumped it up to the $184,500 mark. I'd have to take a look at the statute, but I believe that that's also set to increase in a few years based on inflation. And so we're sort of just always waiting to see what amount the legislature sets it at once it does get updated. And I do see the follow-up question to that, whether it's a California or a federal amount. This is a California specific amount. So each state has its own probate rules and different thresholds for when the court system would be required for managing assets or administering assets.
Okay.
Great questions.
Yep, keep them coming, people.
All right. And then when it comes to protecting you and your pets, so this is where we want to dive right in, right? The revocable living trust tends to be, I would say, tends to be the best method for setting up your very specific instructions, for making sure that you can avoid the court process, and then also make it really clear to whoever you leave in charge for how you want things to be managed. Really, a trust, a lot of people will say, well, what is this document? What is it actually doing for me? All it is a legal contract. So I mentioned before, it's a private document, and we typically will come up with a title for the trust. Now, my name's Alyssa Chow. So for example, we could do the Alyssa Chow Living Trust. It's typically going to be connected to your name individually. Don't worry if there's other Alyssa Chows out there, or if there's other, similar last names to you or similar names. The full trust itself will have a much longer name with a specific date of execution. And you also continue to use your own social security number for all assets that you put into that trust. So there's very, very, very low risk that your trust will be mistaken for someone else's trust. And the great thing about this trust is that it's effective during your lifetime and after you've passed away. And the type of trust that I'm focusing on is a revocable living trust, meaning that during lifetime, as long as you have capacity to do so, you can amend or revoke any of the terms of the trust. So if, you have very specific instructions now about maybe you don't have pets currently, but you may get some in the future, right? If you already have an estate planning portfolio with a revocable living trust, and you have maybe individual people who are the beneficiaries, but later you want to adjust that to provide for any pets that you get later, then, or that you add to your family later, then you can always amend that portion of your trust so that you can provide specifically for those pets. And the great thing about the trust is that it really I like to refer to it as a legal key. And so what the legal key of the trust does is it really just grants access to who you would refer to as your successor trustee or the manager of the trust. It gives them access to all of the assets that they would then need to access to either support you during your lifetime or your pets, or ultimately to distribute any assets upon your passing, right? Because you can have all these beautiful instructions in place, but if they don't have, whoever your trustee is, if they don't actually have access to the assets that they're supposed to be managing, then those instructions aren't going to do a whole lot of good for them, right?
Yeah, Alyssa, we have a question on that point. What exactly does properly connected to the trust mean?
That is the perfect question, because that's my next slide right here, which is yeah, your brain was perfectly on that topic. So how does a trust actually work? Now, generally speaking, only the following assets are actually considered properly funded or connected to your living trust. On the one hand, we kind of talked about titling earlier. Assets that are titled in that name or identifier, which is your trust. Now that would be a formal funding of your asset. So for example, if it's a piece of real estate, we would actually want to transfer your ownership through a deed that gets recorded with the county that transfers your interest in any real estate out of your name individually and into the name of your trust. So that if anyone was to look up the title of ownership for that property, it actually looks like the trust owns the property. From a practical standpoint, this means that, let's say you become incapacitated and the house needs to be sold, or it needs to be rented out and the rental income used for your benefit, right? Nobody will really have authority to step in if you don't have a trust and it's not titled in the trust. But if you've got it titled in your trust, whoever you've designated as what we call your successor trustee, that person then could step into your shoes and then manage that property properly on behalf of the trust. And so what I see a lot whenever I do reviews with folks who may have done maybe a trust years and years ago, usually they come in and they show me what's called either a Schedule A or an Exhibit A, which has a list of all of the assets that they may be intended to connect to their trust, but they never actually went through the second step of either transferring ownership through a deed, or if it's in the case of like financial institutions where there's bank accounts or investment accounts, then they never actually went to the bank to finish any paperwork to connect or title those assets into the name of the trust.
We have a follow-up question. What about certificates of deposit that are currently in joint ownership between spouses?
So anything that you own jointly with someone else, if it's a financial account, if you don't put those assets into your trust, it's sort of like a survival of the fittest model of taking title, meaning that if one person passes, the survivor ends up being the sole owner of that asset. So whether it's with spouses, or sometimes I see it also with children or siblings who might be on accounts together. If you have either CDs or savings accounts, checking accounts, investment accounts, and it's jointly owned, then it just means that if one person passes, the other one will be the sole owner. Now, if you create your own trust and you do want to put your ownership into the trust, especially in your situation, it looks like if it's with spouses, then you could put the entire certificate of deposit into the trust by retitling it. And in that case, then that certificate of deposit would just be managed by the trustees, according to the instructions.
So if the bank account is outside of the trust, then clearly the titling controls, in this case, the joint ownership.
Exactly. Because from the bank's perspective, they want to know who the owner is or who has authority to do something with these accounts. If the trust is mentioned nowhere on the account, then the bank has no idea that the trust instructions exist.
Yeah, they don't know what they don't know.
Exactly.
There is another question. What if you want to fund the trust with cash as opposed to real property or other assets?
Yeah, so you can absolutely set up a trust with cash as well. Typically, what that would mean then, if it's like if it's a bank account, right? If you've got like a Chase account or a Wells Fargo account, then after you create your trust, you can actually convert or retitle that account into the name of your trust, and then it's that funds that asset or that account into your trust. And I would say the beauty of the trust too is that, when you're first setting up a trust and you're funding assets into the trust, you're dealing with assets that you own at the time, but things are going to change, right? You might close accounts, you might sell property, you might acquire additional property in the future. A good rule of thumb for any assets that we're looking at as far as titling goes is that anything that you no longer own just means it's not controlled by the terms of the trust anymore, right? Because the trust isn't listed there, you don't own it anymore, it's gone. Anything new that you acquire, because the trust is a living document, it's something that it continues to exist and is active during your lifetime, you can actually already connect new assets to your trust. So for example, if you want to open up a new bank account somewhere, rather than opening it up just in your name individually, you can actually just give the name and all the information of your trust when you're completing the signature card or the initial paperwork with the bank. And then moving forward, it'll already be in the trust, which is great, right? You've already got this sort of trust basket, and then the new asset that you have, you just throw it in that basket. So that's great. And then same idea with any and then same idea with any real estate too. If you sell real estate, you just don't own that asset anymore. If you purchase additional real estate in the future, you can just tell the title company or your realtor, hey, I've got a trust. I want to make sure that my trust owns this property. And then it's great because they'll probably ask you for a copy of the trust just to confirm that it actually does exist. And then from there, when the deed has been executed by the seller, it will show that the seller is actually granting ownership straight into your trust. So there's already that legal funding of the property into your trust at that point. You really don't have to do like a two-step process where it gets put into your name and bounced into the trust from there. You can just go straight into the trust, which is great.
So speaking of real estate, in San Francisco particularly, or California perhaps, we know that transfer of property in general tends to trigger an increase in basis, and therefore higher property taxes going forward. I would assume, but would love your opinion, that if I, as a single person, am transferring my house into my living trust, my newly created living trust, that does not trigger that increase in basis.
That's correct. So it's really nice. Let's see. So it's really nice because we have what's called a preliminary change of ownership report that I always attach, and all estate planning attorneys will attach to any transfer deed, transferring your ownership interest out of your name and then into the trust. There is an exemption when you're transferring it into your trust because from the assessor's perspective, they just want to make sure that you haven't sold the property to a third party. And so we just let them know ahead of time preliminarily that this is not a sale. There's no transfer of actual ownership from one individual person to another individual person. And then there's no increase, or I should say there's no reassessment for property taxes at the fair market value rate. Now there's still going to be your gradual increase each year, right, for property taxes, unfortunately, but the transfer of ownership out of your name into your trust won't trigger a full reassessment.
Okay, back to the CD question. The follow-up is it relatively easy to transfer existing CDs into presumably the new trust without jeopardizing the CD? And by jeopardizing the CD, I imagine, Alyssa, there are penalties for early withdrawal, that sort of thing, but it's a titling change, right? So nobody.
Right. It kind of, so it's sort of, I have to give you the attorney response, which is it depends. And what I mean by it depends is it depends on what banker you're working with. I've had clients who've gone and it's been no issue, depending on what banker they were working with, to have that CD converted into their trust. Because if you think about it, it's like Pam identified, it's really just a title change. You're still using your own social security number. It's still you for all intents and purposes, but the title is just being slightly adjusted into the name of the trust. I have had clients who have run into issues, though, where a banker has insisted, no, you can't do that. In which case we have a discussion about what the maturity, when it will mature again, or whether the bank is willing to allow them to do, which conveniently segues into the next category of funding, is potentially just designating the trust as a pay on death beneficiary or transfer on death beneficiary of that particular certificate of deposit or asset, in which case then you keep the title, but then if anything happens to you before maturity, or if you pass away, then it's already identified that the trust can claim any of the remaining funds in that certificate of deposit at that time. So unfortunately, it depends. And there's a couple different ways that we can handle it. So either the first category, which is the preferred one of retitling or converting the ownership interest, or designating the trust as the pay on death or transfer on death beneficiary.
Yeah, and excuse me, if you get a banker who doesn't quite understand living trust, then I, as a consumer, always feel free to say, can we talk to your boss?
That's true. Yeah, sometimes
that
we've set up a little conference call too, so that we can try to talk it through. But sometimes it could also be completely separate from what the law allows, and they instead insist that it's an internal policy or something else. So, and I do see Michael's follow-up question to that, which is that if the banker says no, with the provisions of pour over take precedence. And so what Michael's referring to as pour over is that anytime we create a living trust, we always like to do what's called a pour over will as a backup to the trust. And that pour over will essentially would identify that anything that's left in your estate, so if you didn't have a beneficiary, let's say that certificate of deposit was just in your name and you did pass away, then the pour over will can indicate that that asset should be scooped up and poured over into the trust. And so, yes, that is correct, Michael. The pour over will at that point would control, and the certificate of deposit can eventually make its way into the trust. Now, that being said, that the pour over will would only take precedence, again, making sure that the certificate of deposit isn't jointly with someone else who has survived you, and also that you don't already have a beneficiary designated for that certificate of deposit. All right. And then some other assets that you may want to consider that may have to designate a beneficiary kind of falls into that very first category that we talked about on one of the first slides about types of beneficiary, or I guess types of estate planning that people are already engaging in that they may not realize would be through beneficiary designation. So that's going to be not necessarily exclusive, but is almost always going to apply to 401ks, retirement accounts, life insurance policies, and annuities. Those types of assets really only function by beneficiary designation. And so if you were wanting any remaining funds left in those types of assets to be funneled through the trust upon your passing, then you may want to consider designating the trust as the beneficiary. Now, depending on the type of asset, there might be some tax considerations. I always do have to give a disclaimer that I'm not a tax advisor. I'm not a CPA, but I'm happy to work in tandem with your CPA for your overall tax planning when we're considering whether to designate the trust as the beneficiary, particularly when it relates to pre-tax money like a 401k or a traditional IRA. So just keep that in mind when it comes to designating the trust as a beneficiary. And so I do have a little note down there that, and we've touched on this a few times, but assets that do have direct beneficiaries other than the trust will just pass directly to those beneficiaries. Because again, from the financial institution's perspective, if the trust isn't listed as the beneficiary, it's not listed anywhere, and there is a particular person who is designated as a beneficiary, the financial institution will take that as instructions to them that those funds or whatever's remaining should go directly to that designated beneficiary or beneficiaries. Okay. Now, when it comes to trust administration, during your lifetime, Your trust can be set up to ensure that you and your pets are supported if you become incapacitated. Now, this is really important that it's something that you bring up with your estate planning attorney, because the default in California is not necessarily to support any of your pets. The default would be that if you became incapacitated and someone else, meaning your successor trustee, had to step in and administer your trust for you, normally the language there only focuses on you. And so when I'm doing estate planning documents with my clients who have pets, we're really careful to incorporate language that allows the trustee to use any money that's in the trust or that's been funded into the trust for not only your benefit during your lifetime, but also for the benefit and well-being of any pets of yours. Now, at some point, it may be possible that it's either not financially feasible to continue caring for both you and your pets if you're incapacitated, or maybe it's just not feasible on a more practical level because you may need to be moved to assisted living or any sort of like memory care facility that doesn't accept pets as well. If any of those situations come up, I also typically will incorporate language, and this is something you may want to consider, is language about a specific organization like Mickaboo or another charity or organization that you want the trustee to work with to try to make sure that your pets are rehomed in an appropriate manner. Unfortunately, what I've seen in the past when it comes to trusts that lack that information is that the trustee is sort of, because their focus is on only taking care of you, they're trying to spend the least amount of time and the least amount of money in the trust to rehome or do anything for the benefit of your pets, which really is unfortunate because it ends up in a lot of trauma for those pets. And so what I like to make sure we do is just be very specific under your trust that if you're not the one who's managing the trust, then whoever your successor is has very clear guidelines for who they should contact. And they'll thank you for that too, because if they're not avid, bird owners, or they don't have any ties to any charities, they're not going to know where to start. So especially if you already have an existing relationship or you support a particular organization or charity and you know that they do great work like Mickaboo, then it's perfect to be able to sort of name drop that particular organization in the documents. And then whoever the attorney is can also work directly with the organization when they're drafting the estate plan to put some guidelines in place, because different organizations provide different services as well. So it's always important to research ahead of time to make sure that whoever you're naming or whatever organization you're naming actually provides the service that you're looking for. And then upon your passing, the trust can also provide instructions for distribution of trust assets for any desired beneficiaries, whether that's for the benefit of your pets or if it's for any charitable organizations or individual people. The trust will have distribution language that you'll work with your estate planning attorney on for how certain assets and what assets should be allocated to particular beneficiaries. Now, one thing that we really touched on a lot last year was pet trust and sort of all the ins and outs of that. And I know Mickaboo has the link so that you can watch that presentation if you're curious about the history of pet trusts and sort of how we got here today and how it's an available and a viable form of estate planning for either your furry or feathered pets. But for the most part, when we're talking about a pet trust, if you think about your trust as the main document that we're really starting out with, once you've passed away, a pet trust can typically function as what we call a subtrust. So it just branches off from your main trust upon your passing, and you would have that separate pet trust administered according to whatever instructions you'd like to put in place. Normally what happens on a functional level is the trustee of your main trust will transfer any of the allocated funds or assets into the pet trust. And then from there, you can designate either the same person who is the trustee of your main trust or a completely separate pet trustee. That person can then use the assets in the pet trust to care for those pets for the rest of the pet's lifetime. And then upon the passing of that pet or multiple pets, then you can also identify where those remaining assets should be distributed by the pet trustee. A lot of times I have clients who will allocate any remaining funds to a charity in the memory of that pet, or they might designate it to another family member or someone like that. Now, a pet trust is a really formal way that you may want to set up an estate planning estate planning guidelines for the care of pets. It really is like its own little trust. And so that might not necessarily always be appropriate for folks depending on what they want to allocate to the care of their pets. So the alternative can be maybe a more informal method, which I've done with clients as well, which would be, for example, identifying an organization like Mickaboo, where the trustee gives a cash gift to the organization, knowing that the organization then will move forward with their process for rehoming pets, depending on where the origin of the pet and whether or not that pet originally came from Mickaboo or not, right? And so I'm sure Pam and Sarah can talk a little bit more about Mickaboo's process for that. But on the estate planning side, I have had a more informal method where rather than formally setting up a whole pet trust with a separate pet trustee, the person who I'm representing, the client, they end up just allocating a cash gift to the organization with general instructions to fall in line with that organization's rehoming process. That can be a little bit simpler, I guess, of a process rather than the ongoing pet trust. Okay. Actually, you know what, before I get to that, one thing that we haven't really touched on too much, and I know someone had a question prior to the presentation, was who should be the pet trustee, or who should even be the trustee of the trust? There's a couple of, most people will choose family members to be what are called the trustees, right? And I've talked about this a couple times throughout the presentation, but a trustee is really just the person who you've identified who can step in and just follow your instructions, right? The majority of folks will choose family members, friends, any trusted other people in their lives. The only thing I would recommend is that you may want to consider people who are maybe a little bit younger than you. You probably don't want to choose a lot of people as, who might be the same age, because you all may eventually be in the same boat. So we want to make sure that the role of trustee doesn't become vacant, because, while you may have very beloved family members and friends who'd be willing to step in, everyone's aging. And so we just want to make sure that even if they're willing, that you do have some backup people identified as well. And there's really no limit to the number of people you can list as your successor trustees. Typically, we would do that in an order of priority. So this person first, if they're unavailable, then this person, and so on and so forth. If you don't have any family members or friends or other people in your life who'd be willing to step in, there's also what are called professional fiduciaries. California is one of the few states that have this sort of category of employment. Professional fiduciaries are like professional trustees. They are licensed and bonded by the state of California, and they are individuals who you can name them in the documents, and when they step in, this is what they do every day for a living. So they know exactly what all the guidelines are. They know what they can and can't do with the funds. So they have a little bit of a leg up over friends and family who maybe have never administered a trust before and who don't know what the guidelines are. And so you can rely on this professional fiduciary to know exactly what all the steps are without them hopefully doing anything wrong. Now, even if they do something wrong, because they are licensed and bonded, there is insurance, so the trust can be made whole in case they do something incorrect. So just something to think about. Now, there's also institutions out there, like financial institutions, that may have a trust administration sector. So some companies like Merrill through Bank of America, I know that they have trust divisions that may be willing to step in. It's a little bit, if you're more focused though on like a pet trust or trying to provide for any pets, I usually don't recommend the institutions, because it can be a little more, I guess from their perspective, they're more so just looking at, okay, let's gather up the assets and distribute the assets. They're not going to be very boots on the ground, making sure that your pet is sort of taken care of immediately. So I usually recommend individual people if the primary goal is to care for your pets. Yeah. Any questions so far on that? No? Okay. And then just touching on powers of attorney. So we're kind of treating the trust as like the main star of the show, right? We want to rely on that document as much as possible, especially when it comes to any assets that are funded into the trust during lifetime and how those assets should be managed post-death. But there's also going to be your power of attorney, which will supplement the trust. So the power of attorney really just serves as a way to identify what we call an agent who could then assist you during lifetime if you become incapacitated or even before that with anything else financial in nature. So examples of that would be like filing your taxes for you if you can't do it yourself, or directly paying for credit card bills, or dealing with health insurance. You know, it's a lot more sweeping and just fills the gap for anything only during lifetime that the trust doesn't cover. One thing that maybe a lot of people don't know is that powers of attorney do cease to be effective upon your passing, though, because if you think about it, whoever your agent is, they're essentially acting as if they are you. And so if you're gone, then that authority just goes away, right? So they're
unless the person to whom you granted durable power of attorney also happens to be your estate administrator, right?
Exactly, right. And so upon your passing, then, if that same person is also your successor trustee, then they would just shift out of the role as your agent and shift into the role as the trustee.
Yeah. Your conversation about professional fiduciaries has triggered a couple of questions.
Okay.
Putting them in reverse order of how they were asked. Does a professional fiduciary also serve as not only the trustee, but also monetary?
I'm not sure what that question means.
Okay, so Michael, if you can type a clarification there, and while he's doing that, we'll attack the other one, which is, would it be appropriate for a rescue organization like Mickaboo or a volunteer for Mickaboo to be the trustee of the pet trust?
I'm going to leave that up to you, Pam. It's, you know, one thing I will say is that you can always name anyone you want as a trustee, but whether they accept the position is another issue. So I don't know if Mickaboo accepts trusteeship provision or positions.
Yeah, I don't think that we've actually come up with a policy on that, Sarah, unless you know something different.
We haven't, no. I mean, at this time, people will inform us if they've made provisions for something to go to us with instructions for their pets. And we keep a record of that and any details they give us about the pet well in advance so that we know a little bit about them from the time they contact us. But we haven't had anyone naming a Mickaboo volunteer or the organization as a trustee. And I think that's a personal decision for you. You know, Mickaboo volunteers, if you want to approach one of them about that, you could do, but at this time I'm not aware of anyone who has that arrangement in place.
Yeah, and I suspect that before Mickaboo, the organization, were tagged as a trustee, we would probably want to chat with Mickaboo's legal counsel.
Yes.
Make sure that we understand, you know, what responsibilities we would potentially be taking on before, you know, marching into that. We have Michael coming back with clarification. I think it's, you know, does the professional trustee, professional fiduciary, I think is what you called it earlier, also handle the money and pay bills, or is that the role of a fiduciary?
Oh, okay. So they could, yes. The professional trustee. So I should say that the role of a trustee is a fiduciary position, meaning that the person is acting on your behalf and they owe certain duties and responsibilities on your behalf. So the trustee, if they do need to step in, a scenario could be, you know, you have your revocable living trust, you put all your instructions in place, but something happens, or you're later diagnosed with dementia or Alzheimer's or something where you're just really not able to manage the trust any longer. Then the trustee, whether it's a professional fiduciary or a non-professional fiduciary, like a family member or a friend, they would then step in, do what we call marshal the assets, meaning they would identify inventory and get a hold of and control of all of the trust assets. And they could use those assets, if it's cash, for example, they could use it to continue to pay bills like oh, excuse me, they could continue to pay bills like the mortgage. They could pay for property taxes, they could pay for medical bills, really anything that comes in, because we will already have guidelines under the trust that tell them what they can use the funds for. And those guidelines are generally going to be pretty broad, unless there's anything specific that for sure you would need them to cover for you as well. So that would be for anything that's under the trust. And then usually I do recommend that whoever you've designated as your successor trustee, that we also mirror them as the agents under your durable power of attorney for finances. That way there's consistency on the not only trust side, but also on the supplemental power of attorney side, so that the same person is assisting with any and all financial matters, and there's no sort of crossing of the streams or miscommunication among people for paying bills or anything like that.
So the pet trust professional fiduciary trustee person would obviously, you'd want them to have the ability to pay for veterinary expenses, to pay for potential boarding someplace, to pay for food would be
exactly.
Good. Sorry. Okay.
Yeah, so we can always, when it comes to that, right? So we can always put together a list of examples of things that the trustee can pay for. We can also give a general standard for the pet, like pretty much if you want to be very, very general, you can just say anything for the care, health, maintenance, and support of the pet. And then it's a very broad standard. Generally speaking, maintenance and support just means that you're helping to maintain the standard of living at the time that the trustee stepped in. And so whatever that pet was used to at the time is typically what the trustee would continue to cover.
Okay, so if they were used to caviar, then
then they get that caviar still. But yeah, so that's the power of attorney, just a supplemental document to the trust itself on a financial level. Oh yeah, we talked about that a little bit. You having specific language about advocating for pets and just making sure that they can be supported. So whatever language we incorporate into the trust about support for pets during lifetime, if you become incapacitated, we'd want to make sure that that's also incorporated in your power of attorney for finances, so that it's also consistent for any management of asset purposes. And then kind of just, to touch on briefly, healthcare directive, this can be a really important document too. You identify an agent who can either, talk to your doctors, make medical decisions, deal with medication management on your behalf, sign you in and out of the hospital if you can't do it yourself. And so healthcare directive can be really important. That's something that most hospitals and doctors' offices offer directly, but you may want to consider doing it with an attorney through a full estate planning portfolio, because most attorneys will tend to do the general healthcare directive, which is a type of document that can really just be used at any healthcare provider. If you go with your specific healthcare provider, they're going to give you their form. And while other healthcare providers should still accept that form, there's no guarantee that they look at that and say, well, this was done with Kaiser, for example. And if you end up in an emergency room that's not Kaiser, that's sort of up in the air as to whether they'll accept it. So they should, but you sort of never know. So healthcare directive, really important. That's a whole other topic as well too, though. Generally speaking, then, benefits of estate planning overall, primary goal, avoid the probate court as much as possible because of how time consuming, expensive, and public it can be. You also get the benefit of ease of administration according to your affairs. You get to dictate all the terms of how things should be used for your benefit, for the benefit of your pets during lifetime and post-death. And I would say those are the main benefits. I'm a little bit of a control freak also, so I love the idea of being able to control, sort of morbidly. They refer to it as the dead hand as well, meaning that post-death, I still sort of from the grave have control over what happens, or am able to dictate what happens. And so if you're a little bit of a control freak, you don't even have to be like me, but it's something that's a huge benefit that you get to dictate what happens. And with all of that, thank you so much for attending. If you have any questions, here's all my contact information. I'm going to make the presentation available as well. So I'll send that to Sarah and Pam, and then they can share the PDF with anyone who's interested. And then if you want to watch the presentation later, it's also being recorded. So thank you so much for having me.
Yeah, so Alyssa, thank you very much for that presentation. This is what I would call the open Q&A part of things. I see a thank you popping up here. Of course,
Thank you,
we're
Martha.
very thankful for you spending part of your Saturday morning with us. Anybody have other questions? Now's a good time to ask them. I'm seeing more thank yous.
More thank
go
yous.
up.
Yeah, thank you, Alyssa. That was really informative.
Good.
Yeah, I
Yeah.
mean, it's an important topic for sure, and I know that at least one person has asked for your contact information, which is there on screen right now and will be in the written document that we make available to people. I see someone says, "Now I've got homework." Yeah,
Yeah.
that's probably a few of us. Yeah.
Yeah.
Okay,
Makes
and
a
I have
huge
a
difference.
another compliment. Very clear, very helpful. And I have a question here. It says, do you advise completing this process?
I think that's online.
Yeah, I
Oh,
think
Might be a
that's on.
typo.
So there's a lot of options available for estate planning out there. I know there's, if by online you mean like LegalZoom or any online providers for estate planning, those are definitely options out there. Just make sure that you're choosing a California specific program that you work with. And just keep in mind also that sometimes with those types of programs or online services, they tend to use more so the defaults of California, meaning what California law just assumes you would want. And so there's very little customization that happens with those types of programs. So just be a little careful, but it's definitely a good resource if that's something you're interested in.
We have an interesting follow-up question. We in the rescue business have obviously seen times where an animal goes to a vet and their human parent has said, I really can't deal with the expenses of what might be a trivial illness.
Yeah.
So the question is, how does the pet trust insure against early euthanasia of a pet? The scenario where it's something that's very treatable,
Right.
But the human involved, which I guess might be the trustee, doesn't have a clue.
Right.
This sort of thing.
Yeah, and this is something we sort of talked about in our presentation last year, which is there's things that we can put into a pet trust that help to prevent something like that. Now, if someone goes off the rails and does that, then that's really unfortunate, right? We've already maybe gave them guidelines at that point about what they should and shouldn't do. But even if they do decide to do something crazy like that, or they start considering it, we can include what's called a pet enforcer or pet trust enforcer under the trust, meaning, the pet itself can't advocate, right? Meaning they're not going to review accountings of what's happening with the pet trust. They're not going to be able to communicate if their needs are being met or not. And so sometimes people may choose like not only a pet trustee to manage the funds and use the funds for the pet's benefit with those guidelines of how to use them, but you can also do a pet enforcer or pet trust enforcer. So someone who is a separate individual who can then check in on the pet and advocate for the pet when it comes to their well-being. And if the pet trustee ever does get to a point where they think, oh, it makes no sense to keep this trust open, or they, completely go against the terms of the trust and they start looking into other alternatives, the pet enforcer can then step in and either get that trustee removed and another trustee put in, or try to arrange for the benefit of the pet in some other way.
Okay, we have another interesting question, and Sarah, you might want to chime in on this one. Is anyone aware of a temporary care service in an emergency before the pet trustee is able to arrange permanent rehoming? Yeah, I mean,
that's not an easy one.
Yeah, I think it's the it depends question.
I mean, the obvious thing to do is to discuss with your trustee or trustees well in advance, and people you know who know you and your bird or birds, and make as many provisions as you can with people you know that are close to you, that already know your bird's routine, they know what their care requirements are, they may have access to your home, even things that that is by far and away the best thing you can do. If you simply name a professional service like the San Francisco Bird Hotel, then there's still the work of getting the bird there. And, you know, for some people, if they're not comfortable handling birds, even that part might be challenging. So there are, you know, boarding places that we recommend, and avian vets will sometimes help, but obviously there are logistics and costs associated with that. And it may not be easy to handle that emergency for some people. So the more people you familiarize with your bird's routine, and the more people that you talk to so that they already know your bird and your bird knows them, that's going to really help in an emergency situation. So you can start now to just, you know, brainstorm. Okay, well, do any of my neighbors seem pet friendly? Or, you know, if I got someone who lives in the neighborhood who I would trust, and, you know, have a chat with them, because that makes all the difference when things happen unexpectedly.
Yeah, it takes a village for sure.
And tell your partner or your spouse or your neighbor, so even if they're not that person, they know who is.
Yes.
Because we've seen this time and again, if we lose, you know, even people who have been very active within Mickaboo, their spouse had no idea that Mickaboo birds come back to Mickaboo. They weren't even sure which birds they'd adopted and which ones were still officially fosters. And then those fosters ended up being moved elsewhere because we found out later that someone had passed away and action had already been taken. So, you know, putting all this somewhere where it's easy for people to find, even your family members, really, really, really helps, because, you know, when things happen unexpectedly, you know, there's already so much to deal with that, you know, it's very hard if you don't have this information that's already been shared, make it, you know, something people have already in there.
Yeah, and I do encourage my clients as well. Maybe we don't formally incorporate specific organizations or individuals into the documents, into the legal documents, but I do encourage them to also have a list of contacts, right? So once the documents have been completed, they have a full binder. I like to give it to them in a full binder, all organized by tab. And we have a miscellaneous tab at the back. And I do encourage them to have a list of, in case of emergency, contacts and what those people may be willing or able to do as well. And that's really helpful for whoever gets their hands on that binder. Then they know, okay, for the birds, contact this person. For, you know, for the dogs, contact this person. Or for this account, contact this person, right? So it can be, that's more of a practical consideration versus a legal consideration, but can make all the difference.
Yep, and Linda is chiming in that it's really important, if you've got a verbal understanding with someone, to attempt to get that in writing. It's a good memory jogger for both parties, you know, to that particular arrangement. So we have a question about Mickaboo's return policy. And the question is, so foster birds must be returned, but adopted birds aren't? And I know the answer to that one. And the answer is both. Our Mickaboo people, I was going to say, Mickaboo birds are always Mickaboo birds. So
yeah, I mean, obviously, if there are other family members who may want to keep the adopted birds, then we're not going to insist on them coming back to us. We just want to make sure that those people have the support and the information they need to take good care of them. So sometimes there might be a difference in the sense that what the family wants to do might be influenced by that. But also just in terms of, you know, if the birds need medical checkups or anything, then obviously we're paying for the foster birds. So it's important that we're part of the conversation for any treatment that's happening too.
Yeah, I mean, the specialness about Mickaboo is that once a bird comes into our rescue flock, as I call it, we are then interested, if not invested, in the rest of their lives. So we will always be interested in participating in their health decisions, educating, whether the bird is adopted or not. And that's part of Mickaboo's special sauce, if you will. Okay, other questions? Okay, I'm going
thank
to
you.
kind of slow talk here while people are thinking about their last minute questions. The rest of the Mickaboo Saturday events would be this: directly after we let Alyssa go, before we have our bird trivia show at 11:30, you all get to listen to me to walk through the online auction and find the hidden treasures, which include the last minute Warriors tickets that were just donated this morning. So we'll keep the line open. I'm just keep waiting for more questions to come in. I see more additional thanks. And then we've got the little game show idea. There will be a surprise for the winner at the end of the trivia game show, which is expected to take 15-20 minutes. It's meant to be a little dessert after the fairly education intensive estate planning session here. And I don't see any questions coming up. I see a bye now. So that might be
Bye, Linda. Come back later. We'll see you later.
I think so. Alyssa, again, thank you very much for spending part of your Saturday morning with us. This is such an important topic. I hope we can invite you next year to elaborate on another related idea, or to give us updates on what the law is at that point.
Sure. Thank you so much for having me again.
Thank you, Alyssa.
Alrighty.
We really appreciate it.
Yeah. Thank you. Okay. Take care, Alyssa.